As she said, I'm Katie Davis with Omnify. I am honored to be up here with Jeremy Christensen. If Roy is Mr. HSA, I think Jeremy's Mr. Benefits. He's all-knowing and a pleasure to work with day in and day out, and I always learn something from him. So looking forward to this snake-bitten, common COBRA mishaps and making sure we keep you guys all in compliance and nobody runs into any of these. With that, Jeremy, I'll turn it over to you.
Thank you very much, Katie. Thank you to the Omnify team for having me. I get to work with the Omnify team in two ways, as counsel, and then also our firm uses Omnify to administer our benefits too. So with that dual relationship, they're always a terrific group to work with, and I appreciate you guys having me here today. So a little bit about me just really quickly. I'm a partner at Baird Holm, and my team especially. I have another partner, Morgan Kreiser, just became a partner on January 1, and an associate, Carrie Schwab, and it's really a three-person team that does all we do is employee benefits, and so that's, you know, we live, breathe, and sleep employee benefits just like Roy does with HSAs, and so just wanted to give you a little update on my team there. When we talked to Katie and I got together about what we wanted to do and what kind of issues we see with COBRA administration from a legal standpoint and from an administrative standpoint, Katie said we need to make this really exciting. And I said, well, I don't know, given the topic, I don't know, maybe not exciting, but we hopefully can make this interesting for you a little bit. So COBRA is an exceedingly difficult area of administration. One of the most common areas in my practice where I am helping to fix mistakes instead of actually prevent them. I usually get the call when someone has made a COBRA mistake, and then we have to figure out what to do from there. There's lots of moving parts to COBRA, a lot of intricacies in the law, and COBRA is also very deadline driven, which is in itself an area prone to mistakes. So organization is key. Mistakes are available if proper procedures are in place and quality service providers are engaged. And so, as Katie mentioned today, we're going to talk about some of the most common COBRA mishaps that we see from both a legal compliance standpoint, and that'll be me. And then Katie's going to chime in also when she has some tips and some commentary from an administrative standpoint. So our agenda today, to SPD or not to SPD, that's my attempt at culture. Trying to be like William Shakespeare. Initial COBRA notices, and we'll talk about some of the issues with providing your initial COBRA notices in an SPD. Don't be fashionably late. COBRA eligibility or COBRA election notices is what that should say. I'm sorry, that's a mistake. We'll talk about some of the issues with COBRA election notices, especially when they're provided untimely. A complicated relationship, COBRA and Medicare. We just talked about the difficulties with Medicare in an HSA context. Those difficulties don't go away when you're talking about COBRA. Medicare tends to pretty much muck everything up. Bad actors, COBRA and employee misconduct. We'll talk about some of the exceptions, or one of the exceptions to having to apply COBRA, and when we should actually use that, if we should ever actually use that. And voluntary benefits, whether those are subject to COBRA. Same with EAPs and wellness programs. Are those subject to COBRA, and when? And then finally, COBRA issues for FSAs and HRAs. So to SPD or not to SPD, initial notices. In theory, initial notices are already one of COBRA's easiest requirements to satisfy. A group health plan that is subject to COBRA must furnish each covered employee and his or her spouse, if any, an initial written notice of COBRA rights at the time of commencement of coverage under the plan. And essentially what that means from an IRS perspective and the DOL is that the very basic rule is that the initial notice must be provided to applicable covered individuals within 90 days after commencement of plan coverage. And the DOL even provides a model notice for doing this that plans can then customize for their own use. So it's all there set up for you. Ironically, this is also one of the areas where the provision of initial notice tends to get more complicated for employers, and where they then tend to make initial notice mistakes is when they seek to simplify this by putting the initial notice in the SPD. So you're trying to do something easier, and it really just ends up making it more complicated for you. And instead of just sending that standalone notice. On its face, it seems to make sense, right? Both documents have to be disclosed to new participants, the SPD and the COBRA initial notice. So why not cut down on mailings, on paper, et cetera, and kill two birds with one stone? The DOL in its guidance even expressly permits plan administrators to satisfy the COBRA initial notice requirement by using an SPD. And in fact, they've even come out and said they believe that most plan administrators will want to take advantage of what they call the efficiencies of providing the initial COBRA notice as part of the SPD. The theory there, again, is okay, and it sounds good in principle. The problem is often with the execution of doing this. So why then does providing the notice in the SPD actually tend to complicate compliance. There's several reasons for this. The first one is the delivery of the SPD used as initial notice must meet initial notice delivery requirements. So if the plan administrator uses an SPD for the COBRA initial notice, the administrator must follow the COBRA rules regarding distribution of the initial notice. Generally, under the DOL's COBRA regulations, the deadline for delivery will be the same as ERISA's deadline for providing the initial SPD within 90 days after plan coverage begins. So far, so good. The timing is the same. Here's where it gets a little bit more complicated, because beyond the timing, simply following the SPD distribution rules will not satisfy COBRA's requirements for distribution of the initial notice. The SPD of a welfare benefit plan is required to be distributed only to the participant and not the spouse. The COBRA initial notice, on the other hand, as we just talked about, must be provided to both the employee covered by the plan and the employee's spouse if the spouse is covered by the plan. So furnishing the SPD to employee alone is not going to be sufficient to satisfy the initial notice requirement with respect to the employee's spouse. So can you send the SPD to both? Can you just send the SPD to the participant and to the spouse? Sure, but now you're tracking two people to satisfy the SPD requirement when you only had to track one to begin with. And if you provide your SPD electronically, it complicates this even further, because you'd have to have you'd have to have the spouse's email address or something along those lines. And we would recommend a cover letter if you did that, explaining why the SPD is important to both the participant and the spouse, when it normally is a communication aimed directly at the participant. So now we're getting even more complicated, right? We have a cover letter, we've got different mailing requirements, different email addresses, all because you thought you were simplifying this by putting it in one document. The second complication is that the SPD must be ERISA compliant in all other respects. So due to a quirk in the regulatory language, you can only satisfy the COBRA initial notice requirement by using SPD if the SPD is completely ERISA compliant. This means that if there's any issue whatsoever with your SPD, content, format, timing, etc., you can no longer rely on the SPD to provide the initial notice, and the initial notice will be deemed to have not been provided at all. So again, another common pitfall there when you're trying to really simplify this process by combining the notices into one, where you're really just making it more difficult on yourself. So in short, plan administrators should consider the practical aspects of sending a separate standalone initial COBRA notice apart from the SPD. Administratively, more often than not, it's just simpler to do so, especially if you have a TPA doing it, because then the TPA just sends the initial notice and you don't have to work, and typically they don't have your SPD. You offer yourself fewer opportunities along the way to make mistakes. And when it comes down to it, the information required to be included in the initial notice is extremely important information. It's important to covered employees and covered spouses because it affects their ability in certain circumstances to maintain their health coverage. And it's important to plans and employers because failure to comply with COBRA's initial notice requirement exposes them to the possibility of COBRA's liabilities and penalties. So Katie, do you have any thoughts on that from an administrative standpoint?
From the administrative side, what I'm seeing across our book of business is, so far, all of our clients have chosen to keep it separate. And I think that is because of those pitfalls Jeremy just outlined right there. If you have one error in that SPD, then your initial notice is completely wiped out. Plus, then you have the tracking of it. Whereas, for us, if we're sending it, we have all of that record keeping for the regulatory 7 years for those COBRA terms that you have to keep it. And so, yes, it seems like it's more simple to add it in there, but in reality, you have to be darn near perfect to make everything work for you. So yeah, we're seeing so far everybody's keeping it separate and not adding that extra layer of, I guess, if you will, complication to the matter.
All right, so don't be fashionably late. COBRA, and again, this should say, I'm sorry, I apologize for the error. This should say election notices, not eligibility notices. So the second common COBRA mishap here that we want to talk about, but this is honestly probably the most common mishap I see in my practice on a daily basis, is the untimely delivery of COBRA election notices. This is also where employees or former employees, as the case might be, tend to get most litigious with employers when they know they should have received a COBRA election notice and they didn't. They'll go to the DOL and complain, and that's when most of these things end up getting brought up. So the general rule here is that the plan administrator must provide a COBRA election notice to any qualified beneficiary with respect to a qualifying event, a COBRA qualifying event, within 14 days after the plan administrator has been notified by either the employer or the qualified beneficiary themselves, depending on what the qualifying event is, that the qualifying event has actually occurred. So however, again, depending on the qualifying event, the employer or the employee has a responsibility to do that within 30 days. Therefore, in most cases, because the employer and plan administrator are the same, the obligation to notify the plan administrator then kind of melds with the employer's the plan administrator's obligation to notify the participant. And the effective deadline then for providing the election notice is actually 44 days. But regardless of which deadline applies, it's imperative that the deadline is met. Plan administrators should consider the election notices to be their own COBRA insurance policy, is kind of how I've referred to it. For one thing, it reduces the risk of adverse selection. Just to kind of explain what adverse selection is, if you don't provide somebody their COBRA notices, maybe they don't need COBRA right away. Maybe they weren't going to elect it anyway. But then, 6 months down the road, they've got cancer all of a sudden, and all of a sudden they need this health insurance, and you didn't provide the election notice, so you didn't set their clock ticking, and now they can go back and elect retroactive COBRA insurance, and now that's a major hit on your plan where it wouldn't have otherwise been. And this is especially bad for self-funded plans. So in fact, some insurers and stop-loss carriers will actually condition the insurer's obligation to pay claims on the plan administrator's timely provision of COBRA notices. So if you're not timely providing those COBRA notices and the employee comes with some claims, the insurer may just, depending on your contract with that insurer, may just say, too bad, we're not going to pay these claims. Additionally, the election notice is also the plan administrator's last best chance to ensure that the qualified beneficiary knows and can be held to the rules that limit his or her rights to obtain COBRA coverage, including, most importantly, that individual's deadline for electing COBRA coverage, as we just talked about. So what should a plan administrator do if they failed to provide a timely election notice? It's fairly simple. Take immediate steps to correct the failure. There are a myriad of reasons for doing that. For example, failure to correct could result in IRS excise taxes for failure to comply with COBRA. ERISA is $110 per day statutory penalties for failure to provide certain notices that the court can hand down at their discretion. The possibility of extra contractual damages under COBRA's other relief provision. Lawsuits, again, to compel coverage. This is where we typically see them, as when employees become most litigious. Which can create liability for attorney's fees in addition to what your other liability would be. Again, we just talked about increase of adverse selection and then the possible inability to terminate COBRA coverage, even if the qualified beneficiary became covered under another group health plan. So how do you correct? There's no simple solutions guaranteed to work in every situation. The right correction process is highly dependent on the individual facts and circumstances. I know it's a very lawyer thing to say, but that's the truth. In this situation, the general principle is that the qualified beneficiary should be placed in the same financial situation that they would have been in had the failure not occurred in the first place. And at a minimum, a plan administrator should consider sending or resending the election notice as soon as possible to start that clock ticking, offering retroactive COBRA coverage, and even offering to pay claims that the individual may have incurred to date, or even the premiums for COBRA coverage to that date. And just one war story here. I had a client who, this was during COVID, they were running a little thin in some departments because of some cash flow issues. They didn't get a notice sent out to an employee who was really kind of a problem employee and a very litigious employee. And so luckily, because of the COVID's election notice extension rules, they survived that, but it did go to court. And so we were the first ones in the nation that actually went to court on this issue. And whether the regulators had the option to extend these deadlines, which the court found that they did. And because they did, there was no penalty. But the interesting thing here to me was not that, because we knew that was the law and that is how it should have come out. The interesting thing to me is they said that they opined that they wouldn't have assessed penalties anyway, because my client, the employer, had offered to pay for the COBRA premiums for that 6-month period in which they didn't offer. to provide retroactive coverage to this employee, putting them in the same position they would have been otherwise. And so they said, despite the fact that they couldn't levy penalties, they wouldn't have done so anyway. Any comments on that?
No, I would say, Jeremy, we see the same thing. I have conversations almost weekly probably with, I didn't get somebody added. What do I need to do? And let's get them in, let's get the notice out, and we'll go from there if anything else comes from that. I think this is wood, knock on wood. Our clients haven't had any litigation or anything like that yet, but it is important to correct it as soon as you find it.
I mean, employees just seem to know that this is a notice they should be receiving when they lose their coverage. And they also know that there's generally penalties for not doing it. And so, when you have a bad termination or a contentious termination, this is an issue that pops up quite a bit.
Well, and I'll say simple Google search, and you can find the DOL reporting website for their kind of entry for any, COBRA mishaps that you might have. And those disgruntled employees, if they know what they're doing and they're trying to dig, chances are they'll find it. It's not hard to find.
Absolutely. So another area where we often see mistakes is in determining COBRA eligibility, and that's what employers are subject to COBRA, what plans are subject to COBRA, who should be offered COBRA, and when. These are all areas that are prone to having mistakes being made. So employers subject to COBRA. Roy touched on this when he's, I believe, in the Medicare discussion. Occasionally, we will come across an employer who didn't realize that they were subject to COBRA. And this is almost always a relatively new employer, like a startup who's grown really fast, or just a smaller employer who's been around for a long time, but they just recently passed the employee threshold to become subject to COBRA. And so, as Roy said, we start the general premise that virtually all employers are subject to COBRA. We can then back out certain groups of employers, namely the federal government, certain employers themselves who are churches themselves or are sufficiently church-related are not subject to COBRA. And then most importantly for our purposes, and as Roy alluded to earlier, small employers. So who is a small employer? In general, a plan is not subject to, or employer is not subject to COBRA for any calendar year if the employer is maintaining the plan employed fewer than 20 employees on a typical business day during the preceding calendar year. So you're looking at the calendar year in advance of the current calendar year to determine if you're an eligible employer that COBRA is applicable to. This is a complex. A couple words of caution, the rules for counting employees can be complex, especially if you're at or near that threshold. If you're not, it's obviously much easier. So it's highly recommended that you seek assistance in determining whether you are subject to COBRA if that's a question for you. Additionally, if you're part of a control group with other employers, the IRS control group rules may aggregate you with those other employers depending on ownership levels and that sort of thing, causing you to become subject to COBRA. And we see this quite a bit. Well, we didn't know we were subject to COBRA, but you're actually in a control group with this other company. And because the two of you have 60 employees and you only had 15, well, you actually are subject to COBRA. So we see that quite a bit. So again, seek appropriate assistance to make that determination when you need to. We'll talk a little bit in about a couple examples later on this, but another common mistake is not realizing that one or more of an employer's plans is subject to COBRA. The general rule here is that all group health plans maintained by an eligible employer are subject to COBRA. The general definition of a group health plan for COBRA purposes is an employee welfare benefit plan providing medical care to participants or beneficiaries directly or through insurance, reimbursement, or otherwise. The medical care piece is the really important piece there. Effectively, there are certain circumstances where it may not be clear if a plan is subject to COBRA, usually because it's not clear, again, whether the plan provides medical care. Generally, though, the analysis is almost always pretty simple. Does the employer maintain the plan, and does the plan provide medical care? If yes to both, then the plan is subject to COBRA. Again, we will talk about a couple instances later where this determination is not always abundantly clear with respect to EAPs and wellness programs and then volunteer programs. Yeah, I was drawing a blank there. Improperly continuing regular coverage, this is an exceedingly common mistake and is really only tangentially related to COBRA. And what I mean by that is this most often occurs for one of two reasons. The employer misapplied its own group health plan's eligibility terms, or and then failing to realize that an employee should not have been eligible for continued coverage under the plan, regular coverage, or the employer always knows the plan's eligibility rules, but usually out of the kindness of their heart, allows the employee to continue coverage anyway. We saw this a lot during COVID. okay? So with furloughs, leave of absences, et cetera, we want to do the best by our employees. We can't really afford to pay them right now, but we can try to keep them on our health insurance for as long as possible. But technically under the hours requirement under their plan, they were no longer eligible to be covered. So you still see, and you also still see this with good employees with serious illnesses. Employers really want to take care of these people. They're out on leave of absence because they're very sick, and we want to keep them on our coverage. So why do I say this is only tangentially a COBRA issue? Because where the employee individual hasn't lost coverage, COBRA isn't necessarily triggered. It's not triggered. But employees should have lost coverage, and COBRA should have been offered instead of allowing the employee to continue regular coverage under the plan. And so this is important for one big reason, and maintaining coverage under an insurance policy, for maintaining your coverage under an insurance policy or a stop-loss policy for a self-funded plan. Again, what we would see happen is someone was very sick, the employer allowed them to continue on the plan, they weren't meeting hour requirements to be eligible under the plan, they didn't COBRA them out, and an insurance company comes back and says, well, they're not on COBRA, they're not eligible under the terms of the plan, we're going to deny these claims. So in this situation, the proper result is that the employee's coverage is terminated in accordance with the terms of the plan, and the employee is offered COBRA coverage. From there, if the employer wants to pay all or some of the employee's COBRA premiums, that's generally permissible. So it's really okay to do that. And you're coming back to the same conclusion, essentially, except for you've offered them COBRA, they've elected it, and now they're eligible to continue under the terms of your insurance contract or your stop-loss policy. And then finally, what I see a little less often is when an employer overpromises with COBRA, offering more than what COBRA requires. For example, offering COBRA when COBRA is not required at all. We're going to talk about a common example of that on the next slide, but another common example is offering COBRA coverage at termination to an employee who wasn't actually covered under the plan. We see that quite a bit, whether it's just a data mistake or something along those lines, a transmission error. The real issue here is how to fix a mistake, a mistaken offer or mistaken issue of COBRA, continuance of COBRA. Again, there is not a one-size-fits-all solution. And it's highly dependent on the relevant facts and circumstances. The plan should review how they've done this in the past to be consistent. It should consider the relative strengths of the arguments for withdrawing the coverage retroactive to the event that permits termination, withdrawing coverage prospectively, or just allowing coverage to continue in certain instances. As we just talked about, your deliberations on that should be informed by, but not completely controlled by, the views of the insurance company. So sometimes it's okay to push back a little bit on that if you need to. Additionally, healthcare's reform rules on the prohibition of certain rescissions of coverage under the Affordable Care Act should also be considered when doing something along those lines.
Yeah, I would say, during our initial onboarding, we're going to kind of discuss how clients are handling those eligibility notices. And one of the mistakes that I see, Jeremy, too often, and we talk through it, of course, is everybody that's benefits eligible, they get that initial notice. Well, not everybody that's benefit eligible enrolls in benefits. And so giving them, Jeremy kind of alluded to this, is offering them coverage that they're not necessarily eligible for. And so by giving them that initial notice and giving it to everybody, again, you're trying to be efficient and streamline that. But if they didn't enroll in your benefits, they don't have any COBRA rights. But by you giving them that initial notice, you've now extended COBRA rights to somebody that didn't enroll in benefits and shouldn't have necessarily gotten that initial notice. So that's something that we see and we talk through quite often upon onboarding.
Absolutely. Okay, so the next topic is a complicated relationship, COBRA and Medicare. It seems COBRA and our Medicare makes everything a little bit more complicated, as we heard from Roy earlier. So as I just mentioned on the last slide, one area where we see employers offering COBRA when it's not required is when a covered employee becomes entitled to Medicare. This is a tricky area because technically a covered employee becoming entitled to Medicare is listed as a triggering event in the COBRA statute. But in order for it to be a qualifying event, as we talked about a little bit earlier, the triggering event must also cause a loss of coverage. So you have a triggering event, loss of coverage is the qualifying event. But Medicare entitlement rarely, if ever, actually causes a loss of plan coverage for health plans covering active employees, and therefore will rarely be an actual qualifying event, even though it is listed as a triggering event in the statute. Medicare entitlement is more often a qualifying event for retirees and retiree health plans, as that's generally when you'll see it, but you virtually never see it from an active employee. Additionally, if Medicare entitlement does actually cause a loss of coverage, it is a qualifying event for only the spouse and the dependent children, not for the covered employee. And the reason and Roy touched on a little bit of this earlier, the reason entitlement to Medicare doesn't cause a loss of coverage is the Medicare secondary payer rules. I'm sure many of you are familiar with those. These rules essentially say that employers may not offer individuals entitled to Medicare financial or other incentives to opt out of the employer-provided group health coverage. And they prohibit certain actions that take into account an individual's Medicare entitlement. And so dropping an employee from coverage due to that employee's entitlement to Medicare would be an impermissible taking into account of the individual's Medicare entitlement. So that's why it can't be generally a qualifying event under COBRA. A couple other items we see with Medicare. The first is related to special COBRA extension rule for spouses and children of an employee entitled to Medicare. When a covered employee's qualifying event, for example, termination of employment or reduction of hours, occurs within the 18-month period after the employee became entitled to a Medicare, then the employee's spouse and dependent children, but not the employee, become entitled to COBRA coverage for a maximum period that ends 36 months after the covered employee becomes entitled to Medicare. So you get that 18-month extension from the regular 18-month period. The covered employee, however, retains the 18-month period. So the spouse and the children, they get the 36-month period. The employee gets the 18-month period. A common error is mixing and matching those, right? They give the employee the 36-period extension, or they only give the employee or the spouse and the children the 18-month regular COBRA notice. Another area of common mistake here has to do with the timing of when an employee makes a COBRA election and when the same employee becomes entitled to Medicare. And just when I say entitled to Medicare, Medicare entitlement means they've applied and they've actually become covered under Medicare. That's what the term means. So the order of these two events matters for purposes of determining whether an employee's COBRA coverage can be terminated early. When any qualified beneficiary first becomes entitled to Medicare after electing COBRA coverage, his or her COBRA coverage can be terminated early. So if you elect COBRA coverage, then become entitled to Medicare, the plan can terminate your COBRA coverage. This does not affect the rights of the other qualified beneficiaries. So for example, the spouse and the independent children of Medicare entitled employees. However, when a qualified beneficiary is entitled to Medicare before electing COBRA, he or she still has the right to elect COBRA. The COBRA offer cannot be withheld because of Medicare retirement, and this coverage may not be terminated early because of the Medicare entitlement. So really that timing matters of when you elect COBRA and when you become entitled to Medicare.
Yeah, and I would say Jeremy kind of alluded to this on the previous slide, is offering coverage when you don't necessarily have to, and that's one thing I'm working through with a client right now is and the carriers, surprisingly, which insurance carriers almost never offer more than what's needed, but the insurance carrier agreed to allow for 36 months for a dependent on their medical coverage when their plan doesn't necessarily specify that for their employee becoming enrolled in Medicare that they have to end, which, like Jeremy said, is very unlikely that the plan's going to kick somebody off for Medicare. And so, yeah, it's just making sure you dot all those I's and cross those T's if you're going to allow those Medicare eligible employees and their dependents to continue on the plan, drop coverage, and knowing that it's not necessarily a COBRA event.
Okay, bad actors, COBRA and employee misconduct. This is an interesting one. And this topic is one of those rare instances as a lawyer where I hardly ever see an employer actually make the mistake here. But I always get the call that employers come to me first asking my permission to make this mistake before they do it. And so while termination of employment is a triggering event for COBRA, the triggering event of termination of employment doesn't include a termination because of gross misconduct. So when a covered employee is terminated for gross misconduct, there is no qualifying event for the covered employee or the spouse and his or her dependent children. None of them is entitled to a COBRA election if they're terminated for gross misconduct. The kicker here is that COBRA contains no definition whatsoever of gross misconduct. So what does that mean? So I've had employers coming to me saying things like, the guy didn't show up for a week. We really needed him. Now I'm pissed off and I fired him and I don't want to offer him COBRA coverage. Or the SOB slept with my wife. He doesn't deserve COBRA. That's a true story. A client actually called me and said, I don't want to give this guy coverage. He slept with my wife, which is understandable, but I told him to offer the coverage anyway. She violated her non-compete, so I terminated her. Do I need to offer her COBRA coverage? 99 times out of 100, the answer is yes. Yes. You should still offer the terminated employee COBRA coverage no matter how mad you are or how much of a bind they put you in by being a terrible employee or sleeping with your wife. Again, while there's no definition with COBRA itself, the courts have again and again held that gross misconduct is somewhere much higher threshold than a simple for-cause termination. It's up there. So except for maybe the most flagrant conduct that clearly constitutes a substantial and kind of in a willful disregard of the employer's interests, denying COBRA coverage on account of gross misconduct should be avoided. And in all cases should be done in consultation with legal counsel if you decide that's something you want to do. Any decisions not to offer a COBRA election based on the covered employee's gross misconduct should be made after only careful consideration, including of the consequences of litigation for failing to do so. Because these cases often involve disputed facts and mad employees, a less than clear legal standard applies, and because a less than clear legal standard applies here, there's a greater risk of a court challenge and them taking to litigation here if you refuse to offer them COBRA. So I did say 99 times out of 100. So like to channel my, Lloyd Christmas from Dumb and Dumber. So you're saying there's a chance. What about that one time? In my 13 years of practicing in this area, there's been one time, where I advised that the COBRA did not need to offer coverage to a terminated employee. And in this case, the employer was a manufacturing facility, and they had just fired this guy for making terroristic threats to fellow employees. And then immediately after he was terminated, within hours, the employee had made bomb threats at both the employer through a phone call and through social media and over the email. So contacting him in all different ways, telling him he's gonna bomb him. In this case, because this is obviously so very clearly in the best interest of the employer and its employers to sever all contacts with this individual and all remaining ties between this man and his employer, I did advise that it was okay in this instance to use this gross misconduct exception to offering COBRA. But in almost all other instances, guys, there's really no harm usually in offering COBRA, especially if you're an insured plan. They have to pay for it. They pay, so it's not coming out of your pocket generally. Should we stop here and ask for questions since we only have 3 minutes left, I think?
Yeah, we can.
Any questions? I think maybe what you're referring to is because often you're eligible for COBRA, or you're entitled to Medicare after you effectively were entitled to Medicare. I think maybe that's what you're saying is you have to retroact and then deduct that amount from the amount of months you remain. Is that kind of what you're talking about? Yeah. It's usually because there's about a 4 or 5 months lag, I think, between when you're entitled to Medicare and when you get the notice that you're entitled to Medicare. Voluntary benefits, and I can do these fairly quickly here. So I mentioned earlier there were going to be we're going to talk about a couple different kinds of employee benefit plans where the employer might offer, where it's not always abundantly clear whether the plan itself is subject to COBRA. And the first of these is voluntary benefit plans. I get this one a lot. Well, this plan is voluntary, not subject to COBRA, with the implication that because it's a voluntary plan, it's not subject to COBRA, which is not always the case. This is, again, a facts and circumstances analysis. So when we refer to a voluntary plan in this instance, we're referring to a plan that the employer makes available to its employees but does not make any employer contributions to that plan. So it's not, again, whether a voluntary plan is subject to COBRA is dependent on a number of factors. In general, COBRA applies to a voluntary plan if the plan provides medical care, the employer makes contributions to the plan. Again, we're taking that portion out, and then the employer otherwise maintains the plan. And it's the first two that we really need to talk, that's the first and the third that we really need to talk about because that's where it can get difficult. So first, does the plan provide medical coverage? Most common examples, voluntary dental, voluntary vision. That is medical care. These provide medical coverage, obviously. Life indemnity policy, group life and group indemnity, not medical care. They don't provide medical care, almost never do. Those would not be subject to COBRA. Second, does the employer maintain the plan? This is where usually I get the pushback is because, well, they're voluntary, we don't maintain them, they just come in. Well, almost always the employer puts their name on it. The DOL has said, you put your name on that plan, you're maintaining it. If you allow pre-tax deductions through a Section 125 plan, you're maintaining it. So my word of caution here is I would say probably 75 to 80% of the time voluntary plans that offer medical coverage are going to be subject to COBRA because you as an employer are maintaining them. The threshold for not maintaining a plan is very, very low. They come in, AFLAC only speaks to your employees. They sign up through AFLAC. The employer has no involvement in it whatsoever. then we can talk about not offering COBRA for your voluntary plans. EAPs and wellness programs, again, it's a similar analysis. For EAPs, the question here, though, is you're obviously maintaining these plans as an employer, but the question is, do they provide medical care? EAPs, the analysis, and by EAP, I mean an employee assistance program. The analysis is usually pretty simple. 95% of EAPs are broke down into two types of EAP. One, a referral only, or two, one where you get a certain number of free counseling sessions with a mental health care provider, and then they refer you out for a permanent placement. If it's a referral only, it's not providing medical care. It's not subject to COBRA. If you are offering even one free counseling session with a mental health care professional, that is going to be subject to COBRA. That is health care. And so that's basically what the EAP analysis comes down to. Wellness plans, there can be a lot more gray area here, but it's a similar analysis. Does your wellness plan provide medical care? Biometric screenings is medical care. Vaccinations is medical care. So those are likely going to be subject to COBRA. Whereas if you're just paying for a gym membership or having nutritional classes for all your employees to attend, that's not medical care and will not be subject to COBRA. One thing I did want to mention on this, alternative arrangements can be easier than administering COBRA, especially with EAP plans. What we see employers do a lot because EAP plans are really relatively low cost per employee for the employer to maintain, is that they just offer the EAP plan to a terminated employee for 18 months or 36 months, depending, or however long they have to offer to them, instead of offering COBRA. So they just never lose coverage. And then it's in lieu of COBRA, and then you have to deal with COBRA notices and everything on your EAP or your wellness programs. FSAs and HRAs, we've been talking a lot about these. These are exceedingly difficult, especially your HRAs. FSAs are subject to COBRA. They're providing health coverage. What is the COBRA premium? The differences in FSA COBRA compliance versus regular group health COBRA compliance is that you only have to offer FSA continued coverage through the end of the plan year in which the qualifying event occurs. So there's no 18-month requirement. If your account is underspent, your FSA account, meaning you've had more claims than you've actually contributed to your account, you are not entitled to COBRA coverage. So you're only entitled to it for the remainder of the year. And if you have money in that account that you haven't yet had claims issued on, the premium is the combination of the employer-employee share of contributions to that, plus 2% for your administrative fee. And that's how you determine the premium on an FSA. HRAs is much more complicated. I'm not going to get really too far into depth in this. What I would say with an HRA is the premium calculation really has to be done. It's an actuarial analysis, and it's the reasonable cost for determining how much that costs the employer to maintain. And so this is where it becomes difficult for employers when employees elect COBRA coverage on their HRAs, is figuring out what do we charge them for premium to maintain their HRA coverage. And again, it's an actuarial analysis. So if we have any, I don't know if we have time for questions now, but if you have questions for Katie and I, our emails are up there and our phone numbers. Thank you again so much for having me. I appreciate it, and enjoy the rest of your day.
One thing before we break.
Oh, sorry.
Thank you. No, that's okay. Roy slipped me a note. He had to step out, but we do want to mention with his HSA presentation and with our COBRA presentation that yes, you can pay COBRA premiums out of your HSA. He did make a note though, of course, it might encourage some former employees to take COBRA, which some employers might not like, as Jeremy was talking about that gross misconduct. But thank you, everyone. I will turn it back over to Deanna.
Yeah, and along those lines, HSA is not subject to COBRA.
Yeah.